We would like to acknowledge the traditional custodians of the land that we are broadcasting from today. I am currently on Camaragal land, and I'd like to pay respects to elders past and present. So my name is Natalie. I work in the Community Legal Education team at Legal Aid New South Wales, and I'm joined today by Helen, who's our expert criminal lawyer. So Helen, I'll let you introduce yourself, and then we're going to ask people one quick, more poll question before we launch into the webinar.
Hi everybody, my name's Helen Shaw and I'm a criminal law solicitor at Legal Aid in Sydney, and I specialise in criminal law. I don't do family law and I don't do civil law, and I work in local court, district court and Supreme Court of New South Wales. I've been doing this for 22 years, so it's a long time. And I'm really happy to be talking to all of you today and hopefully assisting with different words that you may hear in criminal law jurisdictions.
Thanks, Helen. Just going to ask people this quick poll question before we start, which is really very simple, just to get a bit of an idea of your experience working specifically interpreting in criminal law cases. So do you have quite a lot, a little bit, or none yet, but you're interested? So we'll just give people a second to answer that, just to get an idea of your experience. Thank you very much. I'll just close that poll now and share it with you. So Helen, you can see that 19% of people have quite a lot of experience, about half a little bit, and about a third none yet, but they're interested. So I think that's great. Some people are writing in as well that they've got none yet, but they're interested as well, or a little bit. So that is really good. I think everyone's in the right place.
Yeah, that's a good mix.
And yeah, that is correct. Let me just hide that poll again. And Helen, there's a question for you as well, which is how much experience do you have working with interpreters?
Yeah, for 22 years, I've had a range of clients in different languages. It comes up all the time, needing to work with interpreters and also translators, getting documents translated into foreign languages for clients from English to foreign language, or some clients write their instructions in their foreign language and I need to get it translated into English. So interpreting and translating, it's a big part of my job, working with all of you.
Great, thanks for that. So just quickly, what we will be covering today is I'll be talking a little bit about what we do at Legal Aid, and then we're going to be talking about some common court terminology, documents, legal words we use in documents, legal words used in criminal law, some words about offences, and also there's some new sentences, and that's in New South Wales. So people listening from other jurisdictions, we will try and keep in mind that some things may be different in other states and territories, but a lot of the words we use are common across, but we'll try and keep that in mind as we go through today, because it's great that you're all joining us today. And we'll talk about where else, so some other legal glossaries and that kind of thing. And before I talk about legal aid, if you'd also like to type in now what languages you interpret in, just so we've got an idea of the range of languages or languages that you interpret in, and also if we have any Auslan interpreters as well. So Helen, there's a real range, so Arabic, Mandarin, Spanish, Farsi, Persian, Vietnamese, so really, and many, many more. Kurdish, Comanche, Burmese, Rohingya, Cambodian. So yeah, a lot of newer emerging languages, I suppose, as well as languages that have been in Australia
Wonderful.
For a long time.
Yep.
Okay,
Very
thank you so much for that. Yeah. So
just before we start, I just wanted to thank you all for your job, because without interpreters and translators, we really can't do our job. at all, because we need you to communicate with our clients and for our clients to understand what we're saying. So your job is essential to us as well.
Definitely, thank you. So yeah, people are still typing in what languages they're speaking, which is fantastic. So the way we use interpreters at Legal Aid could be during advice clinics. So that might be face-to-face or more often by phone, especially nowadays. So you might be called to interpret during a legal advice session, or also it might be at court. So we did a workshop a few weeks ago, a panel discussion on more interpreting in courts, and some of you had questions about legal words. So some of the questions you had on that for that session, we're going to be answering today as well. And Helen, someone said thank you for acknowledging the work.
You're welcome. Yeah, your work's very important.
And also a correction for me not to use the word use interpreters, but engage or work with interpreters. So thank you for that. I will definitely take that on board. So other things we do at Legal Aid is what we call minor assistance, which is not working with young people. That just means a type of case we do, which is a small amount of work. So it might be writing a letter or making phone calls on behalf of a client. So that's what we call minor assistance. If you hear that in an advice session, that's what that means. And a grant of legal aid is something that if someone is eligible, so that you might hear the terms means or merit test. So that means there's a requirement for people to get a lawyer to help them in an ongoing way from legal aid. So that means is how much money they earn or own, and merit is about, I guess, how strong a case is. So legal aid, we're funded by government. We have a limited amount of money, so we need to have strict policies to allocate that money is basically what the means and merits test is. And finally, I do community legal education sessions, so that might be workshops to a group of people, and we sometimes have interpreters assisting for those workshops. So some of you might have helped us at community legal education sessions as well. All right. So please do type in your questions as you have them, and we'll just see whether it's something that's relevant to ask Helen as we go along, or if we leave them to the end. We'll just kind of see how we're going and how we're going for time, I think. So as Helen said today, she is a criminal lawyer, and today we're just talking about criminal law words. So some of you might interpret in civil matters or family law matters in the family courts or civil tribunals, but we're not going to be focusing on those matters today. It's really just criminal law matters that we'll talk about today. So I am going to hand over to Helen to start explaining, sort of going through the words that we have on the screen. And if any of you have any other words that you'd like explained, please just type that word into the question box and we can try and include those as well today. So Helen, over to you.
Okay, so mention is a very short appearance in court. It's usually to advise the magistrate or the judge what stage the matter is up to, and there'll need to be a future court date. It might be to set a date for sentence. It might be to say that we've received no documents from the police, various things like that. It is not the final outcome. It is a step in the whole process. Very short time in court, maybe 5 minutes. A hearing or a trial is when somebody has pleaded not guilty and they are defending the charges, and either the magistrate in the local court, I think Victoria used the word county courts, the magistrate will decide guilty or not guilty. In the district court, the judge presides and the jury decides guilty or not guilty. Hearing or trial. Call over is often in the higher courts where the judge is really checking on, are you ready to go to trial? Are you ready to start your case? Do you have any legal arguments which you need to have before the trial starts. It's really checking to make sure everyone is ready or not. An interim hearing or an order is often used, for example, in apprehended domestic violence orders. Police may have issued an apprehended domestic violence order on somebody, and before it comes to court or before it is finalised, there'll be some temporary or interim orders. Things must not do this, must not do that. So in the interim, in the meantime, before it is finalised, there will be some conditions, some orders. An adjournment, you'll hear this a lot, or the matter is adjourned to the next date. So it's not finalised yet. Maybe you've had a mention, you've gone to court and said we're waiting for more documents from the police, and the matter will have to be adjourned to a future date to wait to receive those documents, or the case might be adjourned for sentence or adjourned to come back to court tomorrow to continue the trial. They're all adjournments. So it's postponed until a future date. A stay or a stay of proceedings is a process where you are asking the judge to either temporarily stop the proceedings or to permanently stop the proceedings. And it can be quite difficult to achieve the permanent stay, but one example might be when somebody is terminally ill with cancer, for example. There might be a reason why it's not in the interests of justice to continue the prosecution. A temporary stay might be while somebody has some medical treatment or needs time to save money for their private legal fees. So it's temporarily postponed to a later time. A verdict is guilty or not guilty on the grounds of mental illness. It's like the jury or a judge alone giving their judgment, or what decision. Is this person guilty, not guilty, or not guilty on the grounds of mental illness? Ex parte is when somebody is not present, but a judgment is given in their absence. So somebody is not present in court. So there's some words. And
Helen, we've got a few more. So people are typing in words they're interested in, which is great. If we don't get a chance to get to all of them today, it's still really helpful for us to know what you're interested in to include for next time. But there's just a few, I think, quite common words that people might also want explained. What does it mean to have leave, to get leave?
Leave is permission. So you seek leave to file a document in court. You seek leave to cross-examine a particular witness. So it's seeking permission from the judge or the magistrate. And you might need to do, and we'll get to this late, you might need to put on a notice of motion seeking permission. So it's really asking for permission.
And is there such a thing called if something's listed for reply? What does that mean?
So you reply to the brief of evidence. So police are told they must serve the brief of evidence by a particular date, and you might have the reply, which is you might reply by saying, I'm pleading guilty or I'm pleading not guilty. That's what's meant by reply. It's your answer to the charges.
And we've got call over listed there. Do you know of a super call over?
Yep, with the district court, they're trying to, there was a big delay with COVID-19 and a lot of cases got cancelled, vacated, and they're trying to relist them all now, give them new court dates, but put them all into this super call over and work out which ones will really definitely be going to trial, or which ones maybe there's some successful negotiation and maybe they can plead guilty and not need the trial time, not need all that court time to go to trial. So yes, there are super call-overs coming up soon in the district court.
Okay, we might move on because some of the questions we will be answering in the next few slides. So now we've got some just common legal document words to explain what the differences are.
So affidavit is a sworn statement, and we use this in criminal law to, for example, to support the reasons why you're seeking certain orders set out in your notice of motion. So an affidavit will always go with a notice of motion. The notice of motion lists the orders that you are seeking. Example, vacate or change or cancel the trial date. And the affidavit will have the reasons trying to justify why the judge should do that. Or an affidavit might be by a solicitor just setting out some facts, a chronology of what has happened in the case so far. And again, it might support a particular application, or I might have a client prepare, or I'll prepare for the client an affidavit for their sentence proceedings. It's evidence. It's sworn evidence, but in writing. Deponent is the person that swears or affirms the affidavit. So the deponent is, if I'm making an affidavit, I am the deponent and I sign that. I make an oath, which is a religious promise to tell the truth, and an affirmation is a non-religious promise to tell the truth. Jurors are sworn in or affirmed. Witnesses, interpreters are sworn in and affirmed or affirmed. And one is religious, one is non-religious, but both are equal, promise to tell the truth. A subpoena is a document which you request certain documents be produced, or a person may receive a subpoena to attend court to give evidence, and it's a court order that you attend. The consequence, if you fail to attend court or you fail to produce the documents, a warrant can be issued for arrest. So, example, I might issue a subpoena to police to produce a particular document, and the police are requested to produce those documents by a certain date. And it's by court order. Statutory declaration, we see these all the time. They're not always used in court, but they might be used for passport application. They're a legal document. You also sign a statutory declaration when you travel and you come back to Australia and you declare that you have no plants and no food, and that's a legal document. That's a statutory declaration. Like you're promising that what you're saying is true. So statutory declarations are not so much used in court, but they're still legal documents. But many organisations require a statutory declaration. Hopefully I've explained those, but sometimes they raise more questions.
Yeah, before we move on, there's a few questions around these documents related to interpreters and translators specifically. So what is a translator's affidavit and when are they needed?
I think that might be sometimes police. If somebody has translated a document in the police brief between languages, maybe the police might also require you to either make a statement affirming that you've done this faithfully between the languages, or it might be done in an affidavit form, or it might be that you've translated something for a lawyer or interpreted something for a lawyer, and you're making this affidavit to say that you received this document, or you've looked at translated or interpreted certain things, and you have done it, you've got these qualifications and you've done it to the best of your ability, those sorts of things.
Yeah, I think some people are agreeing with you that that's right. And are there circumstances where interpreters themselves may be issued with a subpoena?
I think so. You probably, some of you may have been
Yeah.
to attend court in a trial. You may have interpreted at the police station. You may have interpreted or translated documents for police in an investigation. You may have had to listen. You may have had to listen to phone calls in a foreign language, which police have recorded, and then you provide a typed translation, typed interpretation of what you've heard, and then you might have to come to court to say, yes, I interpreted this, and the prosecution lawyers might subpoena you to come to court to give that evidence.
Okay, yes, and some people are saying yes, they have had that experience. All right. Can you please explain, sorry, before we move on, just reiterate what is the notice of motion?
Yeah, so it's a 1 or 2 page document, often just 1 page, and it has the orders that you are seeking. So, for example, seeking that the court vacate the trial date, seeking a separate trial from the co-accused, things like that. So it's the order will be, 1 sentence, very short document. You just list what orders you are asking the judge to make, and it's usually district court and Supreme Court that you do this notice of motion. But you must accompany it with an affidavit. Your reasons must be listed in the affidavit, why you think the judge should make those orders.
Great. We might move on and we'll come back to some of the questions later. So Helen, now we've got just some common words that you use in criminal law, and I know people have already asked to explain that difference, that arraignment and those kind of complicated type words, I guess.
And I apologise if some of these may or may not be used in other states. These are definitely used in New South Wales. So summary are matters which are finalised in the local court, summary matters. You might receive a fine, you can still get jail for summary matters, but they are considered less serious and they are dealt with in the local court, not the district court, not the Supreme Court. So that's summary matters. Indictable or indictment. Indictable are more serious charges, and an indictment is presented in the district court or the Supreme Court. An indictment is the charges, the criminal charges printed on a piece of paper. The court copy is always blue. So if you're in court and you see the prosecutor with a blue piece of paper, that is the indictment. The court copy gets the blue one, and the lawyer will usually have a white copy. When somebody is formally entering their plea of not guilty in the district court or Supreme Court, the indictment will be read out to them. The different charges on indictment will be read out and they'll be asked, how do you plead? Guilty or not guilty? That process is called the arraignment. So just on the list, on the right-hand side, we have arraignment. So if you're interpreting at court in the Supreme Court arraignments, the first or third Friday of each month, and the person is being arraigned and asked to enter their plea, my tip is ask the lawyer to give you a copy of the indictment so that you can see it as well as hear the judge or the judge's associate read it out. But it's good for you as the interpreter to have a copy of that indictment. They're the charges that the person is asked to plead to. If somebody is acquitted or the jury acquits somebody, they find them not guilty. It's a verdict of not guilty. Penalty is the punishment. It might be a fine, It might be jail. It might be some kind of a bond or a community correction order or intensive correction order. So it's the punishment. Remand is when somebody is waiting in jail, they're waiting, their bail refused, and they're waiting for their case to be finalised in court. They might be waiting for their trial, or they might be waiting to be sentenced. They're on remand. Their bail refused and they're on remand. Parole and non-parole. If you're on parole, you are serving your sentence, the end part of your sentence, in the community under supervision by community corrections, or probation and parole is what they used to be called in New South Wales. There are two parts to a sentence, the parole period and the non-parole period. The non-parole period is the time that somebody must serve in prison, and it is usually 75% or 3/4 of the total sentence. And then you get released on parole and you serve the final quarter of your sentence in the community under supervision. But if you do anything wrong in that time, you're in breach of your parole and you can go back to jail. So you're still serving your sentence while you're on parole. Custody is, in the criminal law sense, custody is when police arrest you and you're not free to go. You are in police custody at the police station. And if you get sent to the prison, you're in custody. So you're on remand, you're in custody. You're not free to go. I've explained arraignment, and sentence is you've either pled guilty or you've been found guilty by a jury, and then you need to get your punishment. You're sentenced. You get your penalty at the sentence. So lawyers make submissions about the appropriate penalty, and documents, psychologist reports and everything might be tendered, and you get your punishment at sentence.
Okay, we've got a couple of questions about this slide. Is not guilty the same as innocent?
No. So it's a good question. Not guilty is that the prosecution failed to prove beyond a reasonable doubt that somebody is guilty. Somebody might be found not guilty, but it doesn't mean that they didn't do something. It's just the jury found, or the judge alone found, or the magistrate in the local court found that the prosecution had failed to prove the charge to a certain level. So some people that are found not guilty really are innocent as well. They didn't do it. But not every person that is found not guilty is necessarily innocent. And by the same token, some people are found guilty when they really didn't do it either. But that's a different topic. But no, innocent and not guilty are two different things. It's to do with, has the prosecution proved the guilt? Have they produced the evidence to prove it?
Okay, there's another question about what, and I've moved to the next slide because the question is around, is an indictment the same as a summary of charges or a charge sheet? And this is someone in
No.
Victoria, so I'm not.
Yep, good. So
there.
maybe it is in Victoria or another state, but in New South Wales, no. So a summary of charges or a fact sheet, when you're arrested, when you're charged, there'll be a list of charges, court attendance notices, written by a police officer about what you are accused of doing. Whereas an indictment is when we get up to the district court or the Supreme Court, they are the charges which the prosecution is taking you to trial for. And that might be different to what police originally charged you with. But the indictment itself is a piece of paper with each charge or one charge written on it.
Okay, I might get you to go through some of the words on this page, and then we've got more questions, but we're going to come back to them at the end, I think. I think we'll keep going
No
with
problem.
these. Yep.
So sequence in New South Wales, sequence, and you'll hear this a lot in the local court, sequence is a charge, it's a criminal charge. But when police charge you in New South Wales, you get an H number, the third one down, H number. So every set of charges, every charge has an H number, H1, 2, 3, 4, 5, 6, 7. Each one, every time somebody's charged with something, they're given a particular number by the police, and it starts with H. So you'll hear the magistrates say, oh, I've got a set of papers here starting, H, 1, 2, 3, 4, 5, 6, 7. And the person may have 3 lots of different arrests and 3 lots of different charges. They'll each have a different H number. Every time they're arrested, there'll be a different H number. Sometimes you might be arrested once, but have 5 different charges, and each one will have a different sequence number. So I might be arrested for growing the marijuana plants, and under the same H number, and at the same time that I'm charged with growing the marijuana plants, I might also be charged with possessing the marijuana that I've just grown, and I might be charged with supplying marijuana as well. So sequence 1 or charge number 1 might be growing the marijuana. Sequence 2 or charge number 2 might be possessing the marijuana, and charge 3 or sequence 3 might be supplying the marijuana. So that's sequences, charges, they're interchangeable words in that context. But police will also, they'll charge you with something so it's a verb as well. If we're talking language, it's a verb, charge you with something. Form 1 offences, again, it's a New South Wales thing. You're asking the court, local court or district court, you're admitting your guilt, you're asking them to take that charge or offence into account when they sentence you for something more serious, usually. The charge might be a little bit weaker than some of the others, or it might just be a deal between defence and prosecution. The advantage to the accused person is you're not convicted. You admit your guilt, but you're not convicted, and you're not given a separate penalty for it. So you're not given, an extra jail sentence on top of the other jail sentence that you might be getting. So there's an advantage to the accused of having something placed on a Form 1, but the judge still reads about what you've done, but it's not a conviction. Backup charge, for example, you have supply drugs and you have possessed drugs. So I might be accused of possessing marijuana, and the police might think that I've got too much for my personal use, so I must be supplying it, so they charge me with supply as well. I might plead guilty to supply, and then they'll withdraw the possess charge later. Or I might say I'm not guilty for supplying it, but I'm guilty of possessing it because it's mine and I'm going to smoke it and I'm not selling it or giving it to anyone else. If I do plead guilty to the more serious charge, the less serious charge, which is the backup, will be withdrawn later. Agreed facts is something that when you plead guilty, the prosecution and the defence will work out, negotiate agreed facts, and that is what the judge or the magistrate reads. That they might be 3 or 4 pages or longer. And what I do when I've got a client who is foreign language background, I get that document translated for them because I want to make sure that they read in their own language the facts that they are pleading guilty to, that they are admitting. The judge or the magistrate reads that. They don't read 3 folders of the original police brief. So the agreed facts are like a summary, and that is what the person that gives you the sentence reads. Sentence assessment reports, they're the old probation reports. So that's what we now call them since 2018 in New South Wales, sentence assessment report. It's written by community corrections officer who work for corrective services. They will, if you're on bail, you must go to their office or telephone them, make an appointment. If you're in jail, they will find you and they get your agreed facts. Or if you've been found guilty, they'll find out the facts of your case. They look at your criminal record. They talk to you about your attitude to the offence. They work out what you need in terms of drug rehabilitation, those sorts of things. They write the report and it goes straight to the court. So if it's bad report, it's bad news for the defence because you can't hide the bad report. The judge will read it. So if somebody has a really bad attitude, then, and it's written in the report, it's not good for sentence at all. So that report goes straight to court. Objective seriousness, that is, for example, a robbery. The judge will decide how serious is this armed robbery compared to other armed robberies. So you're comparing one example of this charge to other examples of this charge. So things that might make an armed robbery more serious are if somebody was hurt, stabbed, shot, if somebody was hurt during the robbery, how many people were in the shop at the time that the shop was robbed, how much money was stolen, how much planning was involved. Did they have the balaclava, the gloves? Did they cover up the CCTV cameras? If it's very sophisticated and very planned, it would be considered more serious than something that is more spontaneous. So the judge, they compare different sorts of case, they compare different examples of the same case and work out, is this less serious than the normal one, more serious, or in the middle? And you look at all those factors. Special circumstances, this is an application that the defence will always try to make for a sentence. When somebody's getting jail, usually, I said the non-parole period is 75% of the sentence and the parole period is 25% of the sentence. If you have a finding of special circumstances, for example, very young, very old, bad health, really sick, first time in jail, needs help with getting off the drugs, they really need extensive supervision and or there might be mental health issues, there might be many of these factors, or there might only be one. You ask the judge to find special circumstances, and the result of that is that instead of having 75% non-parole period, you might have 60% or may even get down to 50% non-parole and 50% on parole. So it's less time in jail, more time in the community under supervision. So that's special circumstances, and you'll hear that a lot when you're appearing for sentence matters. Any questions?
There are some questions about if you've explained objective seriousness, what is subjective material?
Subjective material is the personal material specific to the person being sentenced. So psychological or psychiatric material. I might have a psychiatric report, my client's mental health, my client's age, my client's personal story, their upbringing, their issues like alcohol abuse, drug abuse, childhood abuse, all those sorts of things, or their reasons for getting involved in the crime. So they're the subjective, personal factors.
And another couple of general questions before we move on to the specific offences. Can you explain what are submissions or representations?
Okay, so representations are something, it's like a submission. I might write to the prosecution, the police or the DPP, and say, look, my client would plead guilty to this less serious charge, but I don't think you can prove X, Y, and Z. I don't think you can prove that. Would you please withdraw that charge? And they will plead guilty to something less serious. And I'll try to prove why, looking at the material in the brief, why that would be more appropriate. That's a representation. Or I might ask them to withdraw everything, all the charges. And I might say, look, I don't think you can prove any of this, and point to different factors, different evidence in the brief, why I think they can't prove it. Submissions can be verbal or written. You make submissions on sentence. You can make written submissions, and you can make oral submissions. And also the submissions, but you can also make, like, representations can also be called submissions. And also in a trial, the lawyers at the end, the prosecutor and the defence, make submissions to the jury. You should find this person guilty for these reasons, or you should find these people not guilty for these reasons. I can just see in red we've got errors.
Yes.
Now this is it stands for electronically recorded interview of a suspected person. So if you're going to the police station to interpret at the police station, you might be in the ERISP, or the record of interview. It's electronically recorded, it's video recorded and audio recorded, and that gets played in court if the person goes to trial. And as the interpreter, you might be sitting in during that interview, and that's what it stands for, electronically recorded interview of a suspected person.
Okay, and one more question. When you were talking about making representations, is that what people might know as a plea bargain, or is that more an American term?
It's more an American term, but yes, essentially yes.
Okay. There are other questions, but I'm just going to move on to, so these are some questions we had from our last panel discussion where people were interested in to know what's the difference, to explain these different terms. So we've got one column which is more assaults or crimes against people, and the other one is more crimes against property. So we're just going to ask Helen to sort of explain those different terms. Thanks.
Now, again, this is New South Wales, so there may be some differences in different states, but common assault is the least serious type of assault, but within that label, there are many different types of common assault. So it might range from verbally threatening somebody, like orally saying something without touching them. That can still be an assault. You're putting somebody in fear, either intentionally or without really thinking too much about, recklessly. Somebody's been put in fear. You might threaten somebody. That can be a common assault. If you hit somebody, that is an assault. It's a common assault if it doesn't cause a bruise or a more serious injury. So when the magistrate or the judge deals with sentencing somebody for common assault, that whole objective seriousness, is this a very serious common assault, or is this the least serious that I've seen? So there's a whole range, a whole scale of seriousness for types of common assault. And in New South Wales, the maximum penalty is 2 years imprisonment for common assault. And it can usually be finalised in the local court.
And
Actual
Helen,
bodily harm.
Sorry, a topical question at the moment is spitting a common assault, and has that been
Definitely.
added in at this time?
Yeah, spitting
That's
is
another thing.
definitely, yeah, a common assault, spitting, yeah. Urinating on somebody, as terrible as that is, some people do it, that's a common assault as well. So actual bodily harm will be, you may have, somebody might be hit and there's like a red mark or a scratch or a bruise. That's bodily harm, that's actual bodily harm, but it's not so serious, it's less serious than grievous bodily harm. Grievous bodily harm is considered really serious injury. That's the definition that will be explained, really serious injury. It's usually something that you might need an operation to fix it, whereas actual bodily harm, you may recover without any surgery, any need for any treatment. But again, there's different levels of actual bodily harm and different levels of grievous bodily harm. But grievous bodily harm is considered really serious injury. There's so many different varieties of it, though. Affray carries a 10-year maximum penalty, but can be finished in the local court. And it's when I'm just looking at the definition here, a person who uses or threatens unlawful violence towards another person and would cause a reasonable person to be at the scene who's witnessing this to be put in fear for their personal safety. And you can do that by yourself, an affray by yourself, or if two or more people use or threaten unlawful violence, then the conduct of both of them is taken into account when considering what the offence. But the threat in affray, the threat cannot be made by words alone. It can't just be words. There has to be some level of physical contact. So that's an affray. Now, a brawl, there's no criminal charge called a brawl, but it's a fight. It's a physical fight. There's no actual criminal charge called brawl. Theft, it's really stealing, and there's so many. When you look at the Crimes Act, New South Wales 1900, there are so many different, because it started in 1900, there are so many different types of larceny of cattle, larceny of all different things. It can be quite amusing just to see the history of involved in the section, how times have changed, and as technology has become more involved, the Crimes Act has had to be amended and added to take into account new technologies. But yeah, if you look in the larceny, it carries 5-year maximum penalty for larceny, but it can be resolved in the local court. And again, when sentencing somebody, how much did they steal? What was their role? Were they the accountant of a business stealing, like larceny by a clerk? Were they employed by the company, or have they stolen somebody's mobile phone? What's the degree of seriousness that has happened? And there's different types of thefts and larcenies, but they're all you just have a look at the Crimes Act 1900 New South Wales. It's quite amusing, some of those, the titles of some of the charges. Robbery involves a threat. It involves a threat, so it's a threat with stealing. It's not, you can steal without a threat, but a robbery involves a threat of violence, an actual threat or an actual violence or a threat of violence, plus the taking of property. And when you steal something, it's not a defence to say you were going to return it. It's an intention to take it away permanently from that person, but it's not a defence to say, oh, well, I was going to give it back. So, yeah, robbery is more serious than stealing. There's a charge, steal from person. And robbery can now in New South Wales be dealt with in the local court, but it involves some violence or a threat of violence. And it's like, give me your wallet or I'm going to hit you. There's a threat, and then you take the wallet. There's the threat. There's the threat of hitting. If you actually do hit them, then that's more serious when you get sentenced than the verbally threatening them. Burglary is not in New South Wales, but it might be in some other states. It's in New South Wales, it's more break, enter and steal. You go into a property and you might open a locked door, or open a door that is closed, or open a window and go in and steal something. In New South Wales, break, enter and steal. And I think it's burglary in other places, but you're entering a property, a home or a building of some description and stealing things.
Okay, thanks, Helen. We're going to go on now to just explain the new sort of sentences people might have heard. There was a question earlier on to explain bonds, but this section might help to clarify that, because we don't use that term anymore in New South Wales.
So we've got the old sentences down the left-hand side. And since 24th of September 2018, we have these new sentences. So we used to have your good behaviour bond, and these new options, you still have to be of good behaviour, and it's an agreement that you're going to conditions for a period of might be 1 year, 2 years or 3 years to be of good behaviour. So I'll take the first one, the intensive correction order. If you're assessed as suitable, it might be that you do it by home detention, but there has to be an assessment. Is your home suitable? There's no victim of violence living there, and that you're a suitable person for it to be monitored under home detention. Intensive correction order, you are under the supervision, you're in the community, you're under the supervision of community corrections or probation and parole, and it is a jail sentence. For each charge, you has to be 2 years prison or less to be eligible to even be considered for an intensive correction order. But you can get up to an sort of aggregate or amalgamated 3 years for intensive correction order, but it is a prison sentence. So it's still very serious. And if you breach it, if you break the rules, if you commit a new offence, if you fail to go to your meetings with your community correction officer, then they can say that you've breached it, and you can go back to the state parole authority for them to decide if you are going to have to go to jail or not. In the past, you used to come back to court when you breached the intensive correction order that the court gave you. Now you don't do that. You go to state parole authority. Less serious than intensive correction order is community correction order. It's like a bond. So it's like the old Section 9 good behaviour bond. You get different conditions. One of them is do not commit any, be of good behaviour, do not commit any more offences. You may have to be supervised. You have to turn up to court if the court calls you to go to court because they think you've done something else wrong. You may get told you have to go to the doctor and get your mental health treatment. You may have to stop taking alcohol or drugs if that was an issue. There's all different possible conditions that the magistrate or judge can impose. You are convicted, it is on your record, and it can be up to 3 years. Conditional release order is not a jail sentence. and it's meant to be for less serious offending. It's can be a bit like the old Section 10. You can get with conviction or without conviction, actually. So you can get these without conviction as well. And again, you have to be of good behaviour, and they may be with or without supervision by community corrections. There might be other conditions. Don't do this, don't do that. Yep, so they're the new sentencing options.
Thanks, Helen. We're almost out of time. So a few things from me. We just got some links to some other glossaries. So there's lots of places where there are words to look up. So and there are links to this in the email that you'll be getting soon. So Law Access New South Wales has a legal dictionary, which has some of these words in them. So that's a good place to look up. And also, for some of you from Victoria, the Victoria Law Foundation has a good legal glossary as well. So we'll include links there. So that could be useful for you to look up as well. And also here at Legal Aid New South Wales, we have lots of brochures and publications with lots of areas of law. And also we do these webinars on different legal topics. If there's anything particularly you're interested in, I know we get a lot of you already at some of our webinars, which is great. That was the content that we had today, and we are right on time, but there are quite a few questions. And what I might suggest is that we even do a part 2 of this. So I know Helen
Yep.
enjoys doing these and is very
Yep.
keen, because there are lots of things that this was just 1 hour, so we had a lot of content that we couldn't cover today, but I can see that there's a lot of things that people are really interested in, even because we know that more than half of you are quite new to interpreting in criminal law matters. So we might have one where we cover some things that we didn't get to today, just like coming back to some basic terms about how do you explain the difference between a barrister and a lawyer and Queen's Counsel and Senior Counsel, all those kind of things that we didn't quite get to cover today. So we've got your email addresses, and if you're happy to get another email from us, we can register for another session in a couple of months. If people want to stay on for another 5 minutes, I can try and cover some of the questions that people have asked already. And remember that we have recorded this webinar, so it will be on our YouTube channel. So we'll send you a link to that as well if there's anything you missed, because I know there was a lot of things to get through. Okay, so there's a few things that I guess were quite complicated words that maybe we can just cover off again if people have time. So the ones that people want. Sorry.
Just before we start, on our website there are also fact sheets and information in foreign languages. So have a look at some of those fact sheets for people in different areas of law going to court. There are many things published in multiple languages that might be helpful to some of you as well.
Yeah, definitely. Yeah, in languages other than English.
That's right.
We're saying.
Oh yes, of course.
That's all right. Okay, so some of the words that people didn't quite catch and might want explained. When we say which website, that's Legal Aid New South Wales. So if you say
legalaid.nsw.gov.au.
Yep, great. Okay, so I'm just going to go through a few of these, just if people have time to stay on. If you need to leave because it is on 3 o'clock, then we understand. And I'm going to start with one question. People are interested to know a bit more about you, Helen, and about why you chose criminal law.
Oh, good. I have to be the most uninteresting topic. I'd rather talk about the words.
Okay.
I don't know what I've just been. I think criminal law is very interesting. I like helping people. It's also about social justice, and I like defending people as well. And I've just been doing this for 22 years, and I'm a bit shy to talk about myself more than that, but yeah.
That's all good. Okay, so just a few of the words to clarify. So when we talked about the offences against people and property. What does it mean when they are aggravated?
There's a few examples of that. So it might, a break, enter and steal, for example, might be aggravated because you knew people are home. So that's one form of aggravation. Might be aggravated because you're in company with somebody else. It might be aggravated because there was violence, corporal violence involved. So there's different penalties. There's more penalty as well, the higher maximum penalty if it's aggravated. But there are some factors that make it aggravated. And I really encourage you, it may sound boring, but again, the Crimes Act has those different charges or circumstances of aggravation. Like when you look at break and enter offences around section 111, 112, and has those different definitions of aggravation and things like that, and different types of larceny. It's quite fascinating. Just as if you like history, you can just see the changes over time as well. But yeah, so in company with somebody aggravates. It's also an aggravating factor on sentence if you're in company with somebody doing a crime.
Okay. All right. Can you please just explain finally, I guess, the difference between hearings and trials? Those words are quite similar. Do they
Yeah,
mean the same thing?
some people use them interchangeably. I tend not to. Definitely in the local court, it's a local court hearing, which means somebody has pleaded not guilty and they're going to hearing in the local court. I don't call that a trial. Trial for me is in the district or Supreme Court when somebody has pleaded not guilty and they're getting tried by a judge and jury, or sometimes election to be tried by a judge only. You can have a sentence hearing as well. So it's really, the hearing is where submissions are made by the lawyers. Person may or may not give evidence, and that's the hearing, the sentence hearing. The judgment will come, that's the result, that's the sentence that the judge imposes, and they give their reasons for it. So that's the judgment. So it's really listening. It's really listening to the evidence. The hearing is hearing the evidence, listening to the evidence, whether it's a trial, a defended hearing in the local court, or a sentence. It's listening to the evidence.
All right. Thanks, Helen. Look, I think we're at the time. We're going to have to leave it there today. There are definitely lots more questions and words that we would love to cover in another part two, I suppose. So listen out for us for our next one, and please register. You will be getting an email in about an hour with some links to what we've been talking about today, and also please do the survey. There is a handout that you can see on your screen, which is just one attendance certificate if you'd like to download that. And there's also an automatic certificate that comes with the GoToWebinar program. So people are just saying thank you to Helen. It was very beneficial and you spoke very clearly, and I think people have learned a lot today. So thank you very much, and we look forward to your feedback and for you to join us next time. So
Yeah, and
thank you,
please
everyone.
give the feedback, like any constructive criticism, positive, negatives, because we learn from it and we listen to what your feedback is. So, yeah.
Thank you. Thanks, everyone from across Australia. It's been great to have you with us today. Thank you.
Thank you.
Bye.